Chief Registrar of the ECOWAS Community Court of Justice, Yahuza Urasama, says by the provisions of Article 24 of the Supplementary Protocol 2005, the decisions of the court can be imposed on member states. He says the Attorney General of the Federation will, however, need to commence the process of enforcement by using the rule of civil procedure of the country. Maugbejosu reports.
This dialogue between the Lagos State Judiciary and ECOWAS Court of Justice is to sensitize the grassroots on its laws and jurisdiction, seek strong ties between national courts and the Community Court of Justice, constitute legal order in the region, and re-emphasize that the regional court is not an appellate court. The Chief Registrar of the ECOWAS Court, Yahuza Urasama, highlights the conditions nationals of member states must meet before filing in applications at its court.
Your application should not be anonymous. The second one is your application should not be pending before another international court. And the last condition is you should be victim of human rights violation. There is no principle of exhaustion of national remedy before you go to the ECOWAS Court of Justice, especially on human rights violation. This is an area where concurrently the National Court and the Community Court of Justice ECOWAS have jurisdiction.
Some of the discussions at the dialogue include concerns on national sovereignty and enforcement of judgment of the ECOWAS Court.
There is no doubt there are some areas where they would have loved to do more, particularly with reference to enforcing their judgments. No nation submits its sovereignty in totality to any partner. And the easiest example that we have underpinning that is what is going on across the world. Russia, Ukraine, Israel, Gaza, and all the other countries. If we are not in a position to also at the end of the day assist in enforcing your judgments, we must operate within our own status, no doubt. But of course, I know there is reciprocity of enforcement of judgments. And then if you are able to register your judgments in our courts, which we then own as if our own judgments, and then we apply our own laws to enforcing them.
Provided for by Article 24 of the Supplementary Protocol of 2005, the decision of the courts are imposable on member states and institutions of the community, and they are immediately enforceable. When a judgment is pronounced by the court and a writ of execution has been sent to member state by the Chief Registrar, Article 24 said that the competent national authority, which is the Attorney General of the Federation in Nigeria, should start the process of the enforcement, bearing in mind that it should use the rule of the civil procedure of the country.
The mission of the Economic Community of West African States Community Court of Justice includes promoting equal justice before the law, protecting human rights in its sub-region, initiate open dialogue and establish mutual trust among member states. Maugbejosu, LTV News.